and thank you for joining us for another episode of I'll Allow It Nevada, your go-to podcast for insightful glimpses into the Nevada judiciary. Today we are discussing the life of a case filed with the Supreme Court of Nevada. To discuss this fundamental topic, I am honored to welcome Nevada Supreme Court Chief Justice Elissa Cadish. It's a privilege to welcome you to the studio, Chief Justice. Thank you for being here.
Oh, thank you for having me. It's my pleasure.
Before we kind of kick off this conversation on the life of a case filed with the Supreme Court of Nevada, maybe we should just touch on a little bit what needs to happen before a case can even be brought to the Nevada Supreme Court.
Sure. So what we do here is hear appeals. So we don't have trials and witnesses and those sorts of things that you may see on television. We have the appeals that happen after that. So before the case can be appealed to us, there needs to be a final judgment entered in the district court below that resolves all of the parties and all of the issues that were raised in the case. That's when there's a final judgment that can be appealed. The only exception to that is there is a procedure to seek what's called writ relief from our court, typically writs of mandamus or writs of prohibition. If someone wants us to try to take up an issue before the case in the district court, that's the trial court, before that is completely done. But there are only narrow circumstances that we take a case up for writ relief. We have discretion on those. So most of what we hear is appeals requiring a final judgment.
I see. So the case needs to be decided upon at a lower court before being brought up to the Supreme Court through an appeal.
Exactly.
Okay.
Then after the case is done, a party who's not happy with the result below can file a notice of appeal. They file that in the district court, the trial court, and then that gets transmitted to us, our clerk's office, and that starts the case opening process.
Okay. So once the case is filed with the Nevada Supreme Court, can you kind of just give us an overview of what that process is like for the case being filed through the Supreme Court?
Sure. So after a civil case is filed, it goes to the settlement conference process. So that may take some time while they get scheduled to have a settlement conference. For most civil cases, they go there. There are certain exceptions, but for the most part, that's true. And then after that, or for criminal or other cases that aren't going to the settlement process, there's an initial screening that's done through the clerk's office attorneys to determine if we have jurisdiction over the matter. In other words, is there actually a final judgment that's been entered by the court? Did it resolve all of the claims and all of the parties that were before that court? Or is it an appealable kind of order in accordance with our rules of appellate procedure? So there's sort of a pre-screening that's done there. And then ultimately the parties go through and brief the matter. There's an opening brief, an answering brief, and then a reply brief, as well as appendices that are submitted, which have parts of the record from the trial court that the parties need to present to us so that we can see what happened below, what the reasoning was, what arguments were presented, what the court did, and what its reasoning was. And then that's all the information that gets filed with us so that we can review what happened and ultimately make our decision on the appeal. I would say that regarding the briefing, I mean, we can talk about the briefing, but the rules of appellate procedure lay out the format, the required length limitations on the briefs that are submitted by the parties, the timing of all that, how long they have to file the opening brief, answering brief, and reply brief, and what needs to be included in the appendices that are filed with us as well. And then also, as part of the briefing, there's a part of the brief where they put in what's called a routing statement. That's their opportunity to talk about whether, under the rules of appellate procedure and given the nature of this case, the case should ultimately stay with the Nevada Supreme Court for the decision regarding their appeal, or whether it should be routed to the Court of Appeals to initially rule on their appeal. All the appeals get filed with the Supreme Court Clerk's Office, and then the Supreme Court, based in part on those routing statements and our evaluation of the nature of the issues, their importance, and the like, then we decide whether that should be initially transferred to the Court of Appeals or remain with the Supreme Court for decision-making. So that's like an opportunity, that routing statement, for the parties to let us know what they think. Do they think there's something that warrants our court keeping it as opposed to the Court of Appeals? Would they be just as happy to go to the Court of Appeals? Maybe they know the Court of Appeals has experience with this type of cases, or they might be a little faster at resolving the case, which is something that's important to them. And so all of that goes into the decision about how the case ultimately proceeds and which court decides it.
So in this process, what role do oral arguments play, and why and are they a significant part of this?
Sure, they certainly can be. Okay. But I should say that most of the cases we have, we decide without having oral argument. Okay. So it's really up to us and in our discretion whether we think a case warrants having oral argument or not. And so the kinds of cases where we want argument include looking at the nature of the issues, how complex they are, whether it would help to bring the attorneys in for oral argument before us to have them clarify exactly what their position is, exactly what happened below in the district court, exactly what outcome they're asking for. Sometimes it can be complicated if there's different issues, and for example, a party may be arguing that a district judge made an incorrect ruling regarding a piece of evidence, but we may need to clarify exactly what they're asking us to do. Are they saying we should reverse and say the case should come out the opposite way, or would we be reversing it and sending it back for a new trial, for example, or that a particular dispositive motion that was granted should have been denied, so the case needs to go back and proceed along the way it would have gone if that hadn't been granted. Sometimes the facts are just not clear, or sometimes it's just important issues that are worth us all having kind of a public discussion about with the attorneys for the parties. And so it can be very important. I think sometimes it can change people's minds on the court. I think there are times when we hear the way it's presented in the oral argument that may trigger something with us to think about it a different way, or to realize something about the record or the case law that we hadn't focused on before. Sometimes it can just confirm what our original thinking before the argument was. But I should say that most of the time when we schedule argument on a case, the justices have not had a conference or had a discussion about that case before. Okay. So we're all kind of coming in cold. Based on our review of the case, we come in and have the argument, and then after the argument, usually immediately after, we go back into our conference room and then deliberate on the case. And that's when we first have a discussion among ourselves about what different people think about the case and vote on it to see what our outcome will be.
So more often than not, oral arguments aren't necessary. So the justices, you review the case individually prior to, and to decide if that's needed. And then if so, you have the oral argument and then confer about it afterwards?
Yes, okay. That's correct. The only thing, which is maybe getting into too much detail, but one thing that also happens early on in a case is the screening, besides deciding whether it goes to the Court of Appeals or stays at the Supreme Court. Also, if it's staying at the Supreme Court, we decide if it's going to be heard by one of our panels of 3 justices or by what we call the en banc court, which means all 7 of us. If the case is an en banc case, then the initial review after a case is worked up is done by currently me as the Chief Justice, and so I review the case and a screening memo that's prepared by the clerk's office and decide whether, if I do think the case is going to be an en banc case, then I look at whether we're going to have argument on it, and generally I make that initial decision. With panel cases, the 3 justices on the panel will review the case once it's been worked up within the court, and the 3 of them vote on whether they want to have argument on it or not.
Okay.
But even if I, as the Chief Justice, say, I don't think it needs argument, we'll just put it on an agenda for us to talk about in one of our conferences. If other justices read it and prepare for that conference and say, I think this warrants argument, then we will go ahead and schedule it. It's not that other people's opinions don't matter. It's just the chief makes the initial call on that as to the en banc cases.
I see. So that's one of the responsibilities of the chief.
Yes, one of many.
Okay, so for any listeners who might not be familiar, could you give a brief overview of the different ways the Supreme Court issues decisions?
Sure. So there are 2 primary rulings that we make in our cases, and that is either we issue an unpublished order or a published opinion. Now, those terms can be a little bit misleading because all of those decisions, every decision we make in every case, barring rare, unusual circumstances, are publicly available, so they're published in that sense. But the difference is that if we resolve a case by an order as opposed to an opinion, it doesn't have precedential value. And what that means is we're ruling on the specific case before us based on our research and the state of the law and the state of the record on that particular case. But the way we analyze that particular case and our ruling doesn't establish precedent for other future cases that may have the same or similar issues. Like generally that's if we're not announcing a particularly new rule or a new nuance, if you will, in the law. So if it's been established before, we're just applying the law to what happened in this case in a pretty straightforward way, then we'll do that by an order.
So that's the unpublished order.
Correct.
Right. Okay.
And in contrast, our published opinions are the ones where we are establishing precedent for future Nevada cases. So that's where we explain and lay out what Nevada law is in this particular area and how it applies in that case. And because it establishes precedent, those are generally going to be longer written decisions where we go into more explanation about the facts of the case before us and our analysis of the law that applies and why we decided to adopt the rule that we're adopting or to apply the rule in the particular way we are given the facts before us, because we want people reading it to be able to see not only what our decision is, but why, so that it's easier for them going forward to apply the rule we're adopting to future sets of circumstances in future cases. So the better we explain what we do and why we're doing it, it makes it easier for future courts to apply that rule going forward.
Okay. So, like, for example, would the Sullivan decision, would that be considered a unpublished order or an opinion?
The Sullivan case, so that was a pretty important water law decision. I believe that was in a published opinion because we were having to establish how the law applied in that particular area. So then in future water law cases that have similar issues, then other courts would know to look at that case and would be required to follow it. Our decisions become mandatory precedent for our whole state. So not only for our own future decisions, but for the Court of Appeals and for the district courts, the trial courts around the state, and any other courts in our state. There are other lower courts. They're all required to follow what we say in our published opinions as mandatory precedent.
Okay, that's really interesting. I wasn't sure about that distinction.
Yeah.
Okay, so you touched a bit briefly already on the justice's thought process on whether or not a case should go to the Court of Appeals. So could you maybe just touch on that maybe a little more before we round out that part?
Sure. So the way our rules are written, the Court of Appeals is designed generally to be more of an error correction court. That means generally cases that raise issues of first impression, in other words, there isn't any Nevada law yet in a particular area, those generally are going to stay with the Supreme Court. Cases that involve situations where there is existing law in Nevada and the question is just whether the trial judge correctly applied that law to a case, those are generally the kinds of issues that we're going to have the Court of Appeals resolve first. But there are exceptions to that as well, because sometimes at first glance, a case may seem like it just requires application of existing law. But once the court digs into it, they may see, it's not that clear and it could be helpful to issue an opinion. So the Court of Appeals does sometimes issue opinions. They do fewer opinions than we do at the Supreme Court, but sometimes it happens. And then there are also certain categories of cases that presumptively go to the Court of Appeals. So the less serious criminal cases or civil cases that have lower amounts at issue, especially, particularly if there's not much at issue in a tort case or a contract case. A lot of family law case types generally go to the Court of Appeals. And when I say presumptively, that's because there may be those categories that generally are going to go to the Court of Appeals, but if they happen to raise a particularly important issue that seems important for the Supreme Court to resolve because it hasn't been resolved before, then we may not transfer it to the Court of Appeals. We may keep that at the Supreme Court.
So in instances when cases are referred to the Court of Appeals and they do discover it's more of an opinion, does it ever get pushed back to the Supreme Court, or once it goes there, it's kind of where it stays?
Once it goes there, that's where it stays. And so if they think it warrants an opinion, they can go ahead and draft an opinion and that would get published. And they work, once the case is transferred to the Court of Appeals, those three judges on the Court of Appeals work independently of us. So they doing their own analysis with their own staff attorneys and law clerks, and then they draft and publish their decision in that circumstance. But then there is a process called a petition for review, which means after the Court of Appeals has ruled on a case, whether it's an order or an opinion that they've issued, a party still dissatisfied can ask the Supreme Court to look at it even after the Court of Appeals ruled. But it's pretty narrow circumstances and pretty few cases that we grant those. We do have discretion on those. The parties have already briefed their appeal and had the Court of Appeals consider and decide their case, so they had their appeal that they have a right to already. So we only take those cases if we think there's really an important statewide issue or a conflict in law that is raised that is worth us taking a look at to clarify. So we don't take very many of those at all, but there is the possibility of them asking the Supreme Court to take a look after the Court of Appeals rules.
Okay, I see. Hi everyone, I hope you're enjoying this episode of I'll Allow It Nevada. We're always striving to bring you valuable insights and education, not just for judicial officers, but for anyone interested in the Nevada judiciary. If you find our content helpful or intriguing, please share your experience with your friends, family, and colleagues. Your support helps us reach a broader audience and ensures that more people can benefit from our discussions. Thank you for listening and supporting I'll Allow It Nevada. So what are some of the challenges the court faces while balancing caseloads and determining when a case should be resolved more punctually?
Sure. It is, of course, important that we not take too long to resolve the cases before us because, real people have their lives often depending on the issues that we're deciding, whether it's civil or criminal or certainly family law type cases. They're important, and those people need to have a final resolution of the issues so they can move forward with their lives. And we certainly take that seriously. So we do our best to get the cases resolved within a reasonable time frame. There are some delays that happen after a case is filed just because of civil cases going to the settlement program. Even in the briefing process, there are some delays because the parties themselves need extra time to finish the briefing process. They've gotten extensions along the way and things can drag out, or they need transcripts of some proceedings and that takes extra time. But once the case is fully briefed, we act pretty quickly to get the cases screened and decide how the case is going to be assigned. So as I mentioned earlier, whether it goes to the Court of Appeals or stays with the Supreme Court, if it's going to be a panel case or an en banc case within the Supreme Court. And then it gets assigned to the particular person who's going to be charged initially with working up the case for the court, whether that's a staff attorney or a law clerk in a particular justice's chambers. That's usually within the Supreme Court how cases would get worked up. And by worked up, I mean that person, that law clerk or staff attorney, goes thoroughly through all the briefs and all of the record and prepares a memo that will be reviewed by all the justices assigned to that case. We try to get those memos done fairly quickly, and then they get considered by the justices on the case, and then we need to, of course, discuss it, deliberate, and vote on what we think the outcome should be, and then we have the law clerk or the staff attorney draft the appropriate order or opinion depending on what we vote the outcome should be. We try to keep it moving, but there is also a balance because sometimes you really dig into an issue and it becomes pretty complicated and you have to do more research and take more time with it, and also balancing the other cases because none of us just have one case we're working on. And so it can be challenging to try to keep all the balls in the air and try to keep them all moving. And then in between, there may be emergency matters that come in that we have to drop things and give that priority for a while before we go back to the other cases we're working on. But we work pretty hard to keep cases moving, and our cases have been reaching disposition more quickly than they used to. The addition of the Court of Appeals, which we've only had since 2015, has been a huge help in helping to keep the cases moving along. And fewer cases the last few years have gotten filed with the Supreme Court, I think partly because of COVID, and since then seems like the fewer cases are coming up, which is also helping us to keep them moving a little more quickly. Our settlement conference program helps to resolve a lot of our civil appeals, which then helps us to be able to focus on the ones that aren't settling. Of course, the fewer cases we have that we need to focus on, the more quickly we can resolve them. And so we all work pretty hard to try to get it done, but we also want to get it right. And you have to balance that. And so we have multiple levels of review on a case, not only the staff attorney or law clerk that works it up, but of course the justices. And then we have an editing team in the clerk's office whose job is to review all of our decisions before they go out and make sure all the citations are correct and everything makes sense and in the context of Nevada law and other principles that apply. And so, and we need to do all that too. We certainly want to get it right. So you're always sort of balancing trying to get things done quickly, but also wanting to be as thorough and accurate as we can.
How can the public access information on ongoing cases or decisions?
Everything filed with the Supreme Court, with rare exception, are publicly available through the court's website, which is nvcourts.gov. You can go there and go to the Appellate Courts page, and you can look up cases by case number or by a party if you know that. Or even if you don't know that, you can just look at what's the upcoming schedule of the court. When do we have arguments scheduled, us or the Court of Appeals? All of that is shown on the website. And you can access the briefs that have been filed. In most cases, you can even look at the record from below in terms of what briefs were filed in the trial court, if there's trial transcripts, and the arguments being made by the parties before us in their written briefs. In addition, when we do have arguments, we live stream those on our court's YouTube channel. And so if you look on our website and you see something interesting is coming up, you can actually watch that argument as it happens through our YouTube channel. And if you're unable to watch it right as it happens, we do post the audio recordings on our website as well, so you can access those and listen to any of the arguments that have happened for the last several years. I'm not sure how long it goes back, what we have on the website, but a pretty good long time where you can go back and listen to those arguments. And of course, when we make our decisions and those are issued, those are available through our website as well. And so we try to be as transparent as we can. And the only time things are hidden is if there's particular privacy concerns that have been established regarding a particular document or matter. But for the most part, everything is there and available. And of course, people can come in person to watch our arguments too. I talked about watching them on YouTube, but when we have arguments, whether it's in Carson City or in our Las Vegas court building, the public is welcome to come in and watch those arguments as well. So that's something that anybody can do, whether you're interested in the law or any member of the public. You can come down and see arguments when we have them going on.
So that kind of ties into my next question. That is obviously quite transparent. Do you have anything else to add about the court's processes in transparency and just building public trust in the Supreme Court?
Yeah, it's so important, and it's concerning for me and for all of us that there has been, in recent years, a reduced kind of trust and confidence in our court system, unfortunately. And I think that it's really important because of that for us to be as transparent as we can. And I'm glad that we do now have all of our court filings and all of our arguments open and available for the public to see. We work for the public, and we know how important that is for the public, not only the press, but any member of the public to be able to access what we do. We also, I would say, when we are challenged in terms of if someone wants to disqualify one of the justices, if they file a motion for that, it's the justice who's being challenged has the opportunity to respond in writing as to that issue. And then the other justices, not the one being challenged, the other justices will consider that and make a decision whether there's a basis under the applicable rules for that particular justice to not be able to rule on that case. So there's checks and balances along the way to make sure that all of us rule on cases appropriately. We're bound by the Code of Judicial Conduct, and there is an independent Judicial Discipline Commission, which in appropriate circumstances, which of course we hope are few and far between, but occasionally there are issues that that commission needs to look into, and they act independently. They look into it and determine discipline subject to appeals to our court. But of course, the judges who are involved in the discipline don't get to rule on any such appeals. So, we try to have those checks and balances and that kind of transparency. The other thing I would say is each of us in the judiciary are required every single year to file with the Administrative Office of the Courts a financial disclosure form that's publicly available as well, where all of us have to list if we have any other sources of income besides our job as a judge, any gifts we've received, anyone else who has reimbursed any expenses for anything that we've incurred. And I think it's important, it's appropriate that we do have that requirement and that is publicly available so that anyone who wants to can look at those. It's not a big secret behind the scenes. Right. And of course, we, as I mentioned, I'll have to comply with the Judicial Conduct Code. So there were only certain things we're even allowed to do to earn income outside being a judge. And all of these things, I think, lead to our judiciary on the whole being pretty good and honest. And I think that the people of Nevada should feel really good that our system is working properly. And we do rule fairly and impartially based on the facts and the law of the case. And I think generally our judiciary works very hard to make sure that that continues to happen.
Yeah, that's great. It sounds like there's a lot of steps to ensure public confidence in the judiciary, not just at the Supreme Court level, but through all levels.
Absolutely. All of our judges are subject to that Code of Judicial Conduct, from municipal court, justice court, district court, Court of Appeals, and Supreme Court. We're all subject to those rules, and we're all subject to potential discipline, and we're all subject to these disclosure requirements. And when we have to run for election, we're also required to file with the Secretary of State. There's contribution and expense reports where you have to list everyone that contributes to your campaign and how much they've given. Right, so it's not some secret hidden process. If you know where to look, and it's not that hard to find, it is all available for everyone to see.
Okay, so before we wrap up this conversation, I do have just one question for you. It's a distinct honor to have the Chief Justice on the podcast. So what are some of the responsibilities of the Chief Justice?
Yeah, it's a wide variety of matters. So I've already mentioned a little bit about some of the screening that I do in the decisions about how the cases will be assigned, the Court of Appeals or Supreme Court panel or en banc. And I actually get an email every single week from the clerk's office with my screening recommendations for the week. And then ultimately I make my decisions regarding those. I also rule on the little procedural orders, such as if people want additional time, usually after there's been an extension of time given. If they're seeking additional time, then I'll take a look at that and review and approve the orders regarding those matters. But there's also administrative responsibilities. So I'm the direct supervisor for all the different departments of the court. So our state court administrator, who heads up the Administrative Office of the Courts, Catherine Stock, she reports directly to me. Our Supreme Court clerk, Elizabeth Brown, reports directly to me. The head of our staff attorneys, our chief counsel, Phaedra Kalicki, reports directly to me. Our marshals responsible for our court security report to me. So if there's a security concern or even some kind of a threat or just something to be aware of, that comes to me. Simple things like I was a brand new chief in January and we had a big snowstorm here in Carson City, and I was the one that had to decide if we were closing the court that day or not. It's a wide variety of issues. I also head up chair the Judicial Selection Commission. So, for example, when a district judge retires during their term, there's a process of appointment to replace that district judge, and we've had a couple of those already. Well, I chair the selection commission that includes attorneys picked by the state bar and members who are selected by the governor, and we all work together. We solicit applications, we review the applications, interview the applicants, and we pick the 3 finalists, and then the governor appoints someone from the finalists. So I've had a couple of those, and we have another one of those appointment processes coming up for one of our Carson City district judges who announced his retirement. There's also other appointments that I need to make to other commissions and committees from around the state. It seems like every week I get an email from somebody saying, well, the Chief Justice of the Supreme Court has to appoint 2 people to this committee, so who do you want? So, I have to think about that and, of course, consider who would do the best job for the state in those roles. Most recently, I was involved in establishing a brand new commission to look at judicial branch security around the state. So I was involved with creating that commission and looking at who should be on it and asking people to participate in that important study that we're just beginning. So it's really a wide variety of matters where, ultimately I'm responsible for all the court employees at some level because of being chief. And so it just adds a lot of administrative responsibility.
Yeah, that sounds like a lot. I mean, you're juggling a lot.
Yeah.
So how often do chiefs cycle through? So how often do we get a new chief?
That is a good question. For quite some time now, we've been alternating every year. But starting next year, we are going to a 2-year term as chief. And so Justice Douglas Herndon is going to be the chief starting next year, and he'll be chief for a 2-year period. So I've been chief just this year. That's been the prior procedure, but we decided this year to change to a 2-year term starting next year, because we think it's just going to be helpful for the court and for all of the staff to have a little more continuity, and probably better for the chief to have a little more time to try to work on their goals and projects, and definitely helpful for people to get some more consistency in how things are run throughout the court. So I'm sure Justice Herndon is going to do a great job as chief. We really appreciate that he was willing to take it on for 2 years, and we'll proceed forward from there.
Okay, good. Do you have any final thoughts or additional insights you would like to share with our listeners?
Well, I would say it's certainly been and continues to be a great honor to be a member of our Nevada Supreme Court, and certainly to be the Chief Justice this year. I may complain a little bit about some of those extra administrative responsibilities, maybe more than a little bit sometimes, but big picture, it really is a great honor to be the head of our court system and to be able to go around the state and talk about the importance of an independent and fair judiciary and the kinds of things we were talking about that we do to try to convey the checks and balances we have and improve the trust and respect people have for our court system. So it's been an honor to be in this role, and a pleasure to be with you on the podcast today.
Well, it's been an honor having you on the podcast. Thank you very much for joining us, and thank you for everything you do for our state. This was all really great information, and I think our listeners will benefit greatly from your knowledge and your insights.
Well, great. I certainly hope so. And, I'm available in my chambers. We take calls in chambers, not about cases, of course, that are pending. But I think it's important for our justices to be in communication with the outside world, if you will, and to understand concerns that people have about the court system.
Absolutely. Thank you very much. A heartfelt appreciation to our guests and to everyone who has tuned into this podcast. Before we wrap up, here are a couple of important reminders. For continuing legal education credit, be sure to complete a certificate of attendance and email it to jepodcast@nvcourts.nv.gov. If you have any questions, topic suggestions, or comments, we welcome your input. Please email them to jepodcast@nvcourts.nv.gov. We value and look forward to hearing from our listeners. Stay tuned for more episodes of I'll Allow It Nevada, released bi-monthly. This is Seth Easley signing off. Take care, Nevada.